live.
Hi, everyone, and welcome to the Federalist Society's PG-15 study break. We're here this evening speaking with Elbert Lin about his experience as Solicitor General in West Virginia. My name is Rady Fitzgerald, and I'm president of the Miami Law Student Federalist Society chapter. And I'm going to break it down by introducing what the Federalist Society practice groups are. We're going to talk a little bit about Elbert and his experience, and then he's going to answer some questions. The Federalist Society's 15 practice groups are organized by substantive areas of law. Each PG, or practice group, is led by a chairman and executive committee comprised of top lawyers from across the country. They meet each month to organize in-person events, webinars, publications, and the panels for the Federalist Society's flagship event, the National Lawyers Convention. You can hear more about the practice groups at fedsoc.org/practice groups. Elbert Lin is the former Solicitor General of West Virginia. He chairs the Issues and Appeals practice at Hunt & Andrews Kurth, LLP, and is also a member of the firm's elected executive committee. Elbert has litigated precedent-setting matters in appellate courts across the country, including in the U.S. Supreme Court, and presented oral argument in more than 50 cases. He is counsel of record for America's Power in West Virginia v. EPA, and was also lead counsel for the states in obtaining the related Supreme Court stay in 2016. During his years on the West Virginia Attorney General's senior staff as the Solicitor General, Elbert oversaw all civil and criminal appeals, managed all legal issues and litigation involving the federal government, and supervised nearly 50 Attorney General opinions. Before that role, Elbert was a partner at Wiley Rein, LLP in Washington, D.C., and a trial attorney with the U.S. Department of Justice, where he primarily litigated suits involving the constitutionality of federal laws and challenges to federal agency action. He also clerked for U.S. Supreme Court Justice Clarence Thomas, U.S. Court of Appeals Judge William H. Pryor Jr., and Senior U.S. District Judge Robert E. Keaton. A magna cum laude graduate of Yale University and managing editor of the Yale Law Journal at Yale Law School, Elbert has been recognized by numerous publications and organizations. Among other accolades, he is an elected member of the American Law Institute, a fellow of the American Academy of Appellate Lawyers, and a public member of the Administrative Conference of the United States. Welcome, Elbert. Without further ado, very happy to have you. So can you start by walking us through your professional journey from law school to becoming a Solicitor General?
Sure. Yeah. So I think if I were to sum it up, it's sort of a winding path of serendipity and hard work, and also sort of stumbling into getting to know the right people. So after law school, I clerked on the Federal District Court in Boston, and immediately following that was an honors attorney at DOJ. I was in the Federal Programs Branch, which is the branch that defends federal agencies and litigates constitutional challenges to statutes. And that was a great experience, but when I was there, I realized that I really hate facts, and instead wanted to be just litigating issues of law. And so I decided that it would make sense to see if I could find my way to the appellate sphere. And it seemed to me the best way to do that was to see if I could clerk at a federal appeals court. So after 2 years at DOJ, I applied to some judges and ended up getting a clerkship with Judge Pryor, now the Chief Judge of the 11th Circuit. And then I clerked for him. And then after that, I went to a firm in DC. And the reason I mentioned the firm is that, and we can talk a little bit more about this if people find it interesting, but I intentionally went to Wiley Rein instead of a different place because I thought there would be a chance to get more interesting experiences. It was a smaller place. It didn't have as many Supreme Court clerks. And the good fortune of being there, when I was there, I worked with Helgi Walker and Will Consovoy, both of whom are former Thomas clerks. And they recommended me to the justice. I thought I was being fired. They actually came into my office and closed the door and asked if I had ever thought about clerking at the U.S. Supreme Court. So that worked out well. And I clerked for Justice Thomas. Then I went back to Wiley. And then in 2012, there was an election, you may remember, and my then future boss, now past boss, Attorney General Patrick Morrissey, was elected to be the Attorney General in West Virginia. And he's the first Republican elected to that office in decades in West Virginia. And he decided he wanted to create a Solicitor General position, which was popular across the country, but hadn't been done in West Virginia. He had worked in DC, and so he put out some feelers, including through the Federalist Society. And word got to me. Somebody asked if I knew anyone who was interested. And I said that I was interested. I had always kind of thought about it. Being an SG, a state SG, is a great job and gives you the opportunity to argue cases and leave an office and all that. So, I put my name in the hat through the Federalist Society, and one thing led to another. I had a good interview with the AG. I had never set foot in the state of West Virginia, but it was, aside from clerking for Justice Thomas, the sort of the greatest career move that I had the good fortune of lucking into. So that's how I ended up there.
So when I introduce, or rather when I get to talk to or interview people who are very successful, and obviously you definitely are very successful, I really appreciate asking about values. So what are some traits that you have come to value or appreciate, things that you may not have necessarily placed so much importance on prior to your experience, either as a Supreme Court clerk or as a Solicitor General, but things that you've come to value and come to appreciate through these really exceptional experiences?
Yeah, that's a really good question. And there's a couple, maybe let me start with sort of the obvious, maybe the most obvious one that was kind of reaffirmed for me. And that's the importance of writing. It both certainly clerking, but in practice and as the SG, writing was hugely important, right? If you can't explain yourself in writing, then you can't make your point. And it was particularly important for me as the SG when I, was in this supervisory role and I needed to rely on other people to get stuff done. And having strong writers sort of is the path to success. If I had to rewrite everything that came through my office, I would never got anything done, right? And we'll get to West Virginia versus EPA and what a monumental task that was. And so, I had the, again, good fortune of hiring some people. Misha Taitlin was my deputy at the time of West Virginia versus EPA. He went on to be the SG Wisconsin. And, he was an excellent writer and still is. So writing, a couple other things, I think, one of them is understanding the policy side of things. So it's really easy when we do what we do to kind of get wrapped up in the law. In particular, appellate lawyers, it's so easy for us to sort of really dive into the law and say, well, this is what the statute says, or this is what the evidence that, the originalist evidence says, or whatever. But judges are humans, right? And we're not arguing stuff to juries, but judges are still humans. And, sometimes when you explain the statute, it's like, well, that's what the text says. Well, okay, but why would that make sense, right? And it may not, right? Especially the sort of justices who I think generally view things the way we do, and the judges, like, at the end of the day, they may say, well, okay, it doesn't really matter. But there's still a benefit to being able to claim, right, the reason and common sense, right? And say, like, this is why this might have been written that way. And that, for me, especially in a role that had such a political element to it, was a really important thing that I think I appreciated before, but didn't fully really kind of get how important that was. And for me, for a long time, it was often a blind side to my advocacy. And I think being the SG really helped me see that. And then I guess the last thing I'll say is the ability to see around corners, right? And the ability to anticipate. And that's important. It was important in my job as the SG because it was my job to look out for the principal and protect the AG's back, right? But similarly, it's, for the people who worked for me, the assistant solicitors and the deputy solicitor, and then now, leading a practice group at Hunton, what makes a really good associate, right, is the few things that we talked about, right? Writing, the sort of creativity and understanding the policy side, but perhaps equally important is the ability to anticipate what's needed next, right? It's a little bit of a mind reading, right? But like, if I made it my job to be able to know what the AG was going to ask me for, right?
Mhm.
When we went into a meeting. And it's, I think similarly, that's what I hope for, expect out of my associates when we work on stuff, right? That they will anticipate 3 moves ahead, right? Well, oh, and then I also looked into this, and then I looked into this, and these are the things that I thought you might want to know about next. So those would be hopefully that answers your question.
Yeah, that was amazing. So thinking back to your time in law school, what best prepared you for your legal career? I'm a law student. We have a lot of law students joining us tonight. Do any particular courses stand out? Any experiences? Maybe joining the Federalist Society, but I think the folks here already are in on that secret. So looking back on it, what do you think was really helpful that you did in law school?
Yeah, so let me start with classes. So I'm going to say 2 things that are a little bit in tension with each other. I'd say, one, take a wide range of classes, right? And I can't tell you the number of times, especially if you want to be an appellate lawyer. Now, if you want to be an environmental lawyer or an SEC lawyer or whatever, like, make sure you take those classes. But particularly for me, appellate lawyers are one of the few remaining bastions of generalism, right, in the practice of law. And where I was going with that is I can't tell you how many times I've had an issue where I've just remembered something random from law school. Like, oh, I mean, I remember that, doctrine, right? That came up in this random class, property, whatever, right? Torts, name your corporations. Like I took business organizations, and I mean, I'm not a transactional lawyer, right? But there's like things that come up that you just remember, right? Like you also remember some from when you take the bar, but I would take a wide range of classes. Here's the thing that I was going to say that's in tension with that. If you are interested in sort of constitutional law and litigation, take FedJur, federal jurisdiction, and take administrative law. So I think both of those are classes that, especially administrative law, I mean, obviously the Supreme Court is super interested in that these days, and there's, it's the 4th branch, right? So the other 2 things, because I don't want to eat up all of our time on this question, is Randy, to a point that you made, like join the Federalist Society, get to know your classmates, right? And get to know your classmates from both sides of the aisle, because there's the sort of the raw, like, networking side of it, right? They're gonna be people they're gonna be potential clients someday, they're gonna be potential referrals, right? I mean, and people who will go to bat for you, especially in sort of the polarized age of today. I mean, if you ever want to be confirmed, right, it'd be helpful to have friends on the other side of the aisle. So that's sort of like the Machiavellian side of it, but also get to know people because they will challenge the way that you think, right? And I mean, I don't know if there are any Yaleys on today, right? But we all know kind of what things are like at Yale now. And when I was there in the early 2000s, it was not as extreme as it is now, but you meet people who don't believe in prisons, right? And you're like, that makes absolutely no sense to me, right? Like literally no prisons at all. Like, what do we do with people? But it challenges you to really think about things that maybe you've not thought about before. And it's also good to just get a good understanding that there's a lot of really smart people in the world, right? And that sort of the humility of that and meeting those kinds of people, I think, gives you a good, it's a good lesson and a good perspective. And then the last thing I would say, and everyone, this is going to happen to you, but like, learn to think like a lawyer. And for me, what does that mean? I remember people when we first got to law school, Guido Calabresi, who was the torts professor at the time, said, if you want to write the great American novel, like go do, like literally walk out now and go do it, because we're going to beat that out of you. And it's true, right? I mean, there is sort of a storytelling element to what we do, but for me, thinking like a lawyer is just very logical, right? I'm always kind of like putting things in boxes and figuring out how the pieces fit together. I mean, I view almost everything these days as a puzzle. And so, take that time that's going to benefit you more, I think, even than the classes that you study, because thinking like a lawyer and being able to solve these problems, whether from a litigation or transactional standpoint, that's what the training is for. So those three things I would say.
Thank you. Could you walk us through thinking about West Virginia v. EPA? Obviously, one of the biggest cases, to many observers, they're calling it one of the biggest cases that the court has decided in a while, in terms of its ramifications on a lot of different areas of our law, on administrative law and federalism. But thinking back to how it started, can you walk us through how the case came about and what it was like in the early stages?
Yeah, so I could talk about this case forever. I will try not to. I'll tell you a little bit about the case, sort of assuming that not everybody knows all the background, and then I have a funny personal story that I will tell, because then you get the inside scoop. But so West Virginia versus EPA, for those who you may not know, was a case sort of 8 years in the making, and it really proceeded in two separate parts, because it was really two cases. The first case started back in 2014, and credit goes entirely to the Patrick Morrissey, my then boss, the Attorney General of West Virginia, who said he wanted to get out in front of this challenge because it was going to affect West Virginia. And what it was the Obama administration promulgated they issued a notice of a rule in 2014. And what it boils down to is it was a rule under the Clean Air Act issued by the EPA to reduce emissions at existing coal and gas-fired power plants. That's what it was. It's called the Clean Power Plan. And the critical question in that rule was EPA wanted to essentially peg the emission reductions to this concept called generation shifting, which meant not simply making coal and gas-fired power plants burn cleaner, but actually shifting the generation from there to other kinds of electric generation, solar, wind, water, renewable stuff. So it's like, we're not just going to do this cleaner, we're actually going to say, you need to stop generating whatever 4 gigawatts and shift that 4 gigawatts to something totally different, right? A completely different kind of energy generation. And that was the question in the Clean Power Plan. And so, the first part of this, the sort of the first 4 to 5 years of it, was challenging the Obama era Clean Power Plan. And, what we managed to succeed in doing is that we brought our challenge in the DC Circuit. We tried to get it stayed. The DC Circuit said no. And then it went, we went to the US Supreme Court, and you all have heard a lot about the shadow docket, right? I mean, this was sort of the first, not just sort of, it was the first time that the US Supreme Court stepped in and stayed an administrative rule before a lower court had even looked at the merits. So we went to the DC Circuit, we said, stay it before we brief it on the merits. They said no. Went to the Supreme Court, said, please stay it, because this is going to cause immediate harm. People are going to have to start making changes, right? Plants are going to start closing down. And SCOTUS said, yeah, let's do it, right? And the personal story is just that, this gets back, Randy, we were talking about like the importance of writing. We sought the stay, and the stay was denied in January of 2016, when I was in the hospital with my wife, who was going to have our third kid. And so they had kind of scrubbed her in for the C-section, and they were getting ready to take her away. And I was looking at my email, because I'm a bad husband, right? And I'm like, oh, look, it says here that the DC Circuit has entered an expedited briefing schedule. And I said, well, that must mean we lost the stay, right? Because like, why would they do an expedited briefing schedule? She said, well, let me know what happens. And then they push her out of the room. So then I get, the little spacesuit on that allows you to go inside there. And I go in, and so, the doctors and the nurses are around, they're getting her ready, and she turns to me, and she doesn't say anything. She's not like, hello, like how she's like, what happened? And so I'm explaining to her, well, I got the email, the DC Circuit denied the stay, and these people, right? These medical professionals, like, who are these crazy people? Anyway, the story goes on. So we lost a stay. So then I worked on actually the Supreme Court stay motion in the hospital. We were stranded there because it was also during a snowstorm. Misha Taitlin had done a great first draft, and I was working on it. And then the end of the personal story is just, as you may or may not know, when you seek a stay in the US Supreme Court, right, it's pretty expedited. And so we filed it. the court asked the other side, the EPA, to file a response. And when the response comes in, you've got essentially, no joke, 24 hours to file your reply. And so at that point, our third kid, who had just been born, was like 2 weeks old, and he wasn't sleeping through the night. And I said to my wife, I was like, well, listen, I'm going to be up all night anyway. Just go to bed, get some rest. So he's sleeping on my chest, and I've got the laptop like on top of him. I mean, there's like a little, you know, one of those like laptop pillows in between. So it's like baby, laptop pillow,
Oh
laptop.
my gosh.
And I'm working on the reply. And anyway, it all worked out. It was just to add to the historic value. It was probably Justice Scalia's last vote before he passed. This is in 16. Anyway, so we got to stay. So that's the first part. And then we're kind of taking a long time in my story. But then the second part of it is, so we stayed, right? And then the DC Circuit heard it en banc, and I argued that along with like 15 other people. And they never came out with a decision, because that was September of 16. Trump is elected, the Trump EPA comes in, they essentially put, you know, they repeal the rule, and they put in place a new rule. And then that brings in part two. And so part two was everyone switched sides, right? And then, so the other side, all the other people, the NGOs and the blue states, they challenged the repeal. And that is the case that ended up going up all the way up to the Supreme Court. So anyway, that's a long way of saying it was a very long road. There was a lot of thinking that went into it, a lot of brainstorming, just kind of literally just sitting around a table, thinking about arguments and putting it together. And with that, I'll let you get to your next question, which I think may get to that.
Yeah. So kind of in the vein of writing, a lot of us, when we're 1Ls, we get really stressed out about writing I'm thinking of like writing my appellate brief for LCOM, for my legal writing and communication class as a 1L. And I remember I was stressed about just my professor reading it, but you were preparing these briefs to go to the highest levels of the federal court system. What is that like, preparing a case, preparing these? I mean, we heard a little bit about it, but if we can kind of hear a little bit more about, I guess, how the sauce is made, right? Like how it feels, what it's like to prepare a case like this, knowing it has the potential to escalate and really make a profound impact on American jurisprudence for a while to come.
Yeah, you know, it's interesting. I mean, I think there's sort of two sides to that are, again, somewhat in tension, right? On the one side of it, kind of as you're alluding to, there's a lot of pressure because, you know, your arguments, whatever you make, right, at the first level, you know, that's what you're stuck with, right? And everything kind of winnows down from there. And so you want to make sure, you know, in this particular context, that the comments that you're filing with the agency, which is where it starts when the rule is proposed, that you've, you know, managed to cover, you know, the breadth of the arguments that you might want to make when you get to court. And then when you get to court, right, you kind of whittle it down to what you think are the better arguments, and then you whittle it down further, right? And so even just taking as an example the stay process, you know, we made a bunch of arguments to the agency, some subset of those to the DC Circuit, and then when we got to the Supreme Court, you know, on the so-called shadow docket, you know, we kind of reduced it down even more to kind of, here are the two critical arguments. This is what's going to get the attention of the court. And so on the one hand, I think there is a lot of, you know, you feel like you know, while you have a long way to go, you're sort of making, you know, you're planting the seeds, and you got to make sure you planted all the seeds that you need to plant at the beginning. Here's the flip side of that. And it's, you know, when you know that the goal is long-term, and you know that you're going to, you know, that especially when you sort of got a tiger by the tail, right? You know, you've got a huge case. There is some peace to knowing that you're playing the long game, right? And you know, the DC Circuit at the time when we challenged this, and the DC Circuit today, is overall not particularly favorable to challenging, you know, rules and regulations, especially if you come from a red state. And so we knew that going in, and, you know, undeterred, right? I mean, we lost several times. I didn't tell the full story, right? And then we got 3-0, the stay was denied, and we didn't even get a dissent from Judge Henderson, who was a Bush appointee. But you sort of know you're playing the long game, and the Attorney General was committed to it, and in private practice, your client is committed to it, and you're going to go all the way. And so you're framing these things for who the ultimate audience might be, and in this case, it was the U.S. Supreme Court. So yeah, I think there's a little bit of a yin and yang to it, but they you can't beat it, right? When you go to law school, to sort of get these kinds of cases, it's the prize. It's the prize at the end.
So before I ask the last two questions that I wrote, I just want to mention to everyone attending, if you have any questions for former Solicitor General Lin, for Elbert Lin, please use the Q&A function. Some great questions are being submitted already. But if you have any questions, please use the Q&A function, and I look forward to seeing them and asking Elbert. But the next question that I have for you, I know that this could be a very long answer. There's probably going to be, I think it's an 1.5 or 2 hour panel on this case and its ramifications and the holding. I think it's going to be, like I said, an 1.5 or 2 hours next week at the National Lawyers Convention. But briefly, for folks who may not have read the case, who might have heard about it, but maybe they have heard different things from different sources, let's say, can you, as briefly as possible, describe what the case is holding at its core and what it means for federalism? I know that's a tall order in a 30-minute study break, but can you
Happy to do it, and I'll bet I can sneak it in the next 2 minutes. Okay. So there's two pieces to this, right? One is, there was a challenge with specific rules. So what's the holding with respect to that rule? And what does it do for, say, EPA's authority to regulate climate change? And that was kind of the headline for the environmentalists. And, here's what I'll tell you it does not do. It does not tell EPA that they cannot regulate climate change. It does not say that greenhouse gases are not pollutants under the Clean Air Act. With respect to EPA, it addressed one specific assertion of authority, which was this concept of generation shifting, right? Can they essentially say, to meet the Clean Air Act, you've got to change the type of electric generation you're using to a totally different type? And the court said, no, in short. Now, that's the sort of environmental piece of it. What's the bigger, so how they get there? And how they get there is, Randy, what you're alluding to, which is the huge administrative law piece of it. And, I would say West Virginia versus EPA is the biggest administrative law decision since Chevron, if not bigger. And, what they held, what they did was, for the first time ever, they used this phrase, the major questions doctrine. And what it had been used before by the court, and had been used to strike down the eviction moratorium that the CDC had put out during COVID. It had been used to strike down the OSHA vaccine sort of mandate or test mandate. And what it boils down to is, it says, look, it's a limit. This gets to your federalism question. What does it do? It enforces the separation of powers between Congress, right, and agencies and the executive. And it says, if an agency is claiming a sort of vast assertion of authority, and here this was one, because it's an assertion to be of the authority to be able to choose, how this country generates electricity, that assertion of authority must be clearly stated by Congress. That's it. That's the major questions doctrine, right? So if there's a major assertion of authority by the agency, based on a statute, you have to have a clear statement from Congress in that statute. And that, I think, is dramatic. Now, lots of questions follow from that. What is major? And if it's major, how clear is clear enough? And that's, something, Randy, as you alluded to, you can have whole panels and whole textbooks that talk about it. But the major questions doctrine, I think, is something that you're going to see a lot of going forward. And the one other thing that I'll say is, there's a lot of questions about, does this case say anything about non-delegation? And it doesn't. And my view of the case is that it intentionally avoided it. I think it is a totally different question. And maybe the way to think about it, I would suggest to people, is this case says, did Congress delegate? That is a different question from, if it did delegate, did it have the power to do that, right? And that's the non-delegation question. So that's sort of an, I don't know, an antecedent question that, or a postcedent question, if it's even delegated. And I think they just didn't reach that here. So that's in, I guess, 4 minutes, what the major holding of the case was.
Okay. Before we move on to our attendee questions, I want to ask you about the Federalist Society practice groups. So could you tell us a little bit more about how you got involved and about your leadership of your practice group in the Federalist Society?
Yeah, so the practice groups are a really great way to become more involved with FEDSOC. I think it's, when you're a practicing attorney, it's easy to, you can be involved in your sort of local geographic practice group, like in Richmond here, Richmond, Virginia, we have one. The practice groups are national and they meet basically once a month by video conference now. And we, keep an eye on substantive developments in whatever our particular areas. So my practice group is Federalism and Separation of Powers. And I got involved with practice groups in general, I don't know, maybe 10 years ago. And I just reached out to leadership at FEDSOC and said, hey, I'm interested in playing a bigger role in the sort of substantive programming that the society does. I don't think I was on FedSep initially. I can't remember. Maybe it was telecom at the time. And then kind of meandered my way over to Federalism and Separation of Powers. And it's rewarding. And you feel like it gives you an excuse to kind of stay on top of this stuff, to interact with, some really interesting people who are part of the practice group, and to kind of, bring your expertise and knowledge to the rest of the society.
Thank you. So our first audience question comes from Jacob. He's actually one of our members in our Miami Law chapter, Go Canes. He asks if you would recommend working out of law school either for the state solicitor general, maybe through the state attorney general's office, or going the private practice civil appeals route to gain that early career experience after law school.
Yeah, so I think if you, the premise, I think the assumption here is that you want to do appellate law. And I would say between private practice and state government is the way to go, because you're going to get more opportunities to get on your feet. Opportunities that you won't necessarily get in private practice. There's a lot to be said for private practice in the sense that, law firms are built in a way to make it easy for you to focus on nothing but the law. I mean, I'll tell you, when I was state solicitor general, I mean, I was fixing my own copy machine, right? Just binding there was one night where we were binding a Fourth Circuit brief. I had to figure out how to use the comb binder, right? Like, I mean, it was crazy. When you're in private practice, you don't have to deal with all that stuff. And so there's value to that. But if you want to, get a lot of hands-on experience right out of the gate, a lot of the people that I hired who worked for me in West Virginia, they got, 4 or 5 arguments a year, right, in the West Virginia Supreme Court, which you'll never see in private practice. So, so the short answer is yes, I would totally look at state SG places. I will tell you, many of those places are looking for clerks. And I would say, if you're asking yourself, what should you do right out of law school? If you want to be an appellate lawyer, certainly, but I think even if you just want to be a litigator, I would highly recommend that you go clerk somewhere, whether it's federal district court, federal appellate court, state Supreme Court, state appellate court.
Great. Another one of our audience members asks if you can talk, or could you please talk about a time where you argued a case in federal appeals court and disagreed with the argument your client wanted you to make. I would expand that. I mean, I would say you don't have to necessarily answer about federal appeals court, but I think this is something that sometimes can be really relevant for members of the Federalist Society, where we're passionate about a textualist or an originalist view of the law. That's me kind of changing the question a little bit. But how do you handle having a client who may want you to make an argument that you may not personally agree with? How do you square that?
Yeah, I mean, there's a lot of different answers to that, and a lot of it depends on what the specific factual scenario is, right? But maybe what I would say is, at the end of the day, right, for the most part, the client is the boss. Sometimes it's a little bit different in government where, like, for example, at DOJ, the client is the United States, and the United States is sort of a nebulous entity that doesn't actually talk to you. Right, but certainly in private practice, and even in the SG's office, we'd have agencies that had positions that they wanted to take. And, ultimately your duty is to the client. And if the client insists that that's an argument that they want to make, you make it. Now, there's an offshoot to that, which we can get to in a second. But, how do you handle that situation if you think the argument is wrong? For example, I mean, set aside what you think is morally incorrect, but if you think it's wrong or, strategically unwise, then that's part of the advocacy, right? Like, you're not only arguing and making arguments to a court, and then, it's your job to try to persuade your client that it doesn't make sense to make that argument. But at the end of the day, if you're unsuccessful in doing that, I think barring some, really extraordinary situation, if the person is your client, right? Unless you're going to withdraw from representation, you make the argument. Now, you mentioned sort of some of the stuff that we feel passionately about. It's a real interesting wrinkle when you're in state government and the attorney general confronts this question of, does he have a duty to defend, right? And we saw a lot of that going on. When I was serving there was right before the gay marriage decision came down, and we were litigating a lot of the West Virginia had a ban on gay marriage, and Virginia had one, and so we were dealing with a lot of those things. And that's an interesting question for the state AGs to have to think about. And we would, I mean, for me personally, the standard that I use to advise my boss on, so we had no qualms about defending the gay marriage ban, but if we had something similar, on the other side, for me the question was always, is there a non-frivolous argument that we can make, right? Because the AG has sort of sworn a duty, I think, and there's differing theories on this, but for me, it was always, is there a non-frivolous argument that you can make to defend the law? And if you do, then that's the duty that the AG has. But yeah, it's an interesting, there's a spin on this, which is, what do you do if you have an argument that the court disagrees with, or the court is going to disagree with, and you and your client are on the same page? How do you handle that? I have a funny story about that. I argued something in the Fourth Circuit once where Judge Niemeyer, his first question to me was, this is a paraphrase, but it was essentially, do you have any other arguments other than what you have in your brief? And it was a little bit, my reaction was a little bit like is there somebody else I can talk to? Is there a manager or something?
I was just going to say, do you ask a federal appeals judge for their manager?
Yeah, I was like, well, there's two other people sitting there. I talked to one of them. That was an interesting experience. But
okay, so our last question from the audience comes from Dustin. Dustin asks, do you see this case potentially having a big impact on state administrative agencies? What are your thoughts?
That's an interesting question. And the reason why it's interesting is because state government is not always structured in the same way, right, as the federal government. And just to give you an example, in West Virginia, every rule that is made by the agency has to be approved by the legislature. Now, it's done in sort of a rubber stamp kind of a way. Like there's a slate of rules that goes before the legislature, and generally speaking, I think there's depending on how controversial there may be scrutiny, but they just sort of approve them for the most part. And so there, what you have is it's very different, right, from the federal system. Like if it's a rule, it's been passed by the legislature, though it was developed by the agency. So you don't have this question of did they mean to delegate this? Because the answer is, well, yeah, they approved it. So I think the answer to that question is it depends, on the particular constitutional structure, but you could see a state Supreme Court of the right composition, borrowing from West Virginia versus EPA.
Well, there you have it, folks. Our conversation with Elbert Lin, former Solicitor General of West Virginia. Just to keep in mind, for next week, we have The Future of American Democracy, Merrill v. Milligan and Moore v. Harper. That's next week's PG-15 study break. We hope to see you there. Thank you so much, everyone, for joining. We really appreciate your time. We hope you got some of your questions answered and enjoyed our study break. Thanks so much, everyone. Have a good night.